again. Okay, welcome everybody to this hearing of the sport arbitration moot. Today we have the Université Paris-Saclay acting as counsel for the appellant against the Pontificia Universidad Católica de Rio de Janeiro acting as counsel for the respondent. The panel is composed by Ms. Rombach, Ms. Gomez, and Mr. Cambreleng. Everybody is correctly connected, therefore all is good on my side. I leave the floor now to the panel to start this hearing as you deem appropriate. Thank you.
Thank you very much, Julia, and well, welcome everyone to today's hearing. First of all, before starting the hearing, I also want to congratulate both teams for making it up until this round of 16. So congrats, well done. I'm sure it will be a marvelous hearing that we'll have today. And before we start with the hearing, well, obviously, because I took the floor, we've decided that I will be chairing the panel. Therefore, before we start, just a couple of housekeeping matters to deal with. As you know, if you're not talking, please mute your microphones so that we avoid any distractions to the party that is pleading. With respect to timing, you have received the procedural order. You have already done this a few times during the moot, so you will have 20 minutes each. And we will now, we will ask you a bit about the structure that you have decided. And also with respect to timing, Ms. Rombach will be taking the role of timekeeper, so that we distribute a bit the roles. Thank you for that. And this is an important criteria, so we invite you to also keep track of the timing yourselves. So having said that, the parties, have you already agreed on a time allocation and the structure of your pleadings?
Yes, indeed, we have, Mr. Presiding Arbitrator. We reached an agreement with counsel for respondent that in regard to the time allocation, we'll plead for 10 minutes each time, leaving 1 minute for the rebuttal. In regard to the order of the pleadings, respondent will start on the procedure, the appellant will answer, and then on the merits, the appellant will start and respondent will answer. Thank you, Mr. President and members of the panel.
Okay, perfect, understood. Okay, so now we can start the hearing, but before I give the floor to the respondent, I understand for the procedural matters, I would like to ask the parties whether they have any objection towards the composition of the panel, appellant.
No objections on our behalf on this panel. However, we'll be making relevant challenges in the submission to Mr. Vax and Mr. Jaime, of course.
It is understood that we are Mr. Vax, Mr. Jaime, and Mr. Bautzai, but I understood.
Thank you.
The respondent, any objection?
Yeah, on behalf of the respondents, no objections to the constitution of this panel. Thank you.
Thank you very much. So without further ado, the respondent, the floor is yours for the first part on the procedural matters. Thank you.
Thank you, Mr. Chairman. But before Mr. Chairman, co-arbitrators, opposing counsel, good afternoon. My name is Thomaz Aquino, and together with my colleague Gustavo Awad, we represent FIFA, respondent in these proceedings. Members of this tribunal, what the appellant will try to sell you is simple. Nothing is his fault, and everyone is to blame. When it comes to the procedural issues, the appellants justify his omissions over an alleged unawareness. But let us be aware, there is nothing new under the sun. With this in mind, the respondent will divide its presentation in 2 points. Firstly, that the challenge against Mr. Vax and Madam Maima must not be upheld. And lastly, that the evidence relied upon by FIFA is admissible. But before addressing the challenge, let me just assure this tribunal that we are aware of the possible issue regarding the deadline on the file of this appeal, since the FIFA's statutes and code of ethics states that an appeal against a decision of the adjudicatory chamber must be filed in 21 days, which was not observed by the appellant. However, in the spirit of good faith and procedural integrity, especially considering the legal action chapter of the appeal committee's decision that indicates a new 21 days term, respondent does not contest the jurisdiction of CAS to hear the present dispute. Moving on to the challenge of the arbitrators, first regarding Mr. Vax, his challenge must be dismissed, since his position regarding vaccination was known for a while. Mr. Vax's resume, available to the parties much before the comments were made, informs that he acts as the president of an NGO dedicated to eradicating diseases. This is an organization such as the Planetary Health Alliance, the International Society for Infectious Diseases, and the Global Health Network. All of them have one thing in common. They all strongly defend the distribution of vaccines. So the appellant received this information and agreed with Mr. Vax's appointment. According to CAS procedural rules, after receiving the resume, appellant had 7 days to challenge Mr. Vax's nomination, but they didn't. The LinkedIn comment only expressed in a new way, a known opinion of the arbitrator. But even if we ignore that and focus only on the comment itself, it does not justify the exclusion of Mr. Vax. The Swiss Federal Tribunal faced the issue of an arbitrator's online comments when voided the CAS Award of 2020 involving the Chinese swimmer Sun Yang and the World Anti-Doping Agency. In this case, the Swiss court understood that 2 criteria must be present to uphold an arbitrator's challenge over online statements. First, the use of offensive expressions and a lack of relationship between the term of and the actions commented upon. In the Sun Yang case, the arbitrator made a link between the Chinese population and animal torture. The wording was extremely offensive, with the arbitrator calling people from China bastards, sadics, inhumans, and honestly other words that I prefer not to repeat in these proceedings. Also, the Swiss tribunal understood that there was no connection between the terms used to demean the Chinese population and animal torture. So both criteria were met. Comparing to Mr. Vax's case, none of the requirements exist. Mr. Vax made a comment claiming that people who opposed to vaccination were uneducated over the constant exposure to fake news and conspiracy theories, and that it is everyone's duty to educate them. There is nothing offensive on his wording, and there is a clear relationship between the terms. When calling anti-vaccination defenders, such as Mr. Adam, uneducated, his goal was to, in fact, educate them. There is nothing here to raise reasonable doubt as to his impartiality. When it comes to Madam Umaima, her challenge must also be disregarded, since she complied with all of her duties. Firstly, 1 day after her firm hired a former member of FIFA's in-house legal team, she sent an email informing this event to the members of this tribunal. The hiring itself does not create any conflict because the associate hired was not involved in the disciplinary proceeding against Mr. Adam. He ended his contract with FIFA before this arbitration was even filed, and he does not work directly with Madam Umaima. If much, this situation is comparable for others in the green list of the IBA guidelines on conflict of interest, such as a relationship between an arbitrator and the council through a professional association. Regarding Madam Umaima's 4 nominations for arbitral proceedings in which the FIFA was a party, this also does not raise grounds for the challenge. Even if she was indeed appointed by FIFA, which is not clear here, it does not affect her impartiality, and it does not require disclosure. According to the IBA guidelines on conflict of interest, on a footnote in the item 3.1.3, in certain types of arbitrations, such as sports, the level of expertise demanded from the arbitrators are so high that it's practiced to draw arbitrators from a small pool. In a proceeding before CAS, for example,
A gente vai chegar terça em Lima.
the arbitrator must appear on CAS list.
Três.
In these situations, the IBA guidelines indicates that no disclosure of the repeated nomination is required. Again, no conflict whatsoever. Finally, when it comes to the evidence relied upon by FIFA, there is also no grounds to challenge their admissibility. The evidence were a written document that consists in a transcript of the whistleblower's statement received from Heartland's Department of Justice and a telegram message sent by the appellant. Regarding the written evidence, parties heard during a criminal proceeding are not to be considered FIFA's witness, as established by the case Marco Polo Del Nero versus FIFA. This can be explained by remembering that they were under oath, liable to perjury, and was submitted to a formal condition set by the criminal procedure. Therefore, this evidence does not need to comply with the requirements of a FIFA's witness statement, such as the need for cross-examination. This could only affect the evaluation of the evidence, but not its admissibility. We must also remember that the Swiss law, applicable in these proceedings, allows the use of anonymous witness statement. The screenshot of the telegram message is also admissible. In the case Football Club Metallist versus UEFA in PAOK, from the appellant's list of authorities, it was held that the transcription of an illegally recorded phone conversation with a player was unlawful, but admissible. This understanding was expressed in the award as follows, and I quote, "Even if evidence might not be admissible in a civil or criminal court in Switzerland, this does not automatically prevent a sports federation or an arbitral tribunal from taking such evidence into account," end of quote. Given appellant's inability to rebut or otherwise refute the veracity of the screenshot, there are no reason to render it inadmissible. This brings me to the end of my pleading. On behalf of Respondent, FIFA, I hereby request on the procedural issues that this tribunal dismisses both challenges against the arbitrators, Mr. Vax and Madam Umaima, and render FIFA's evidence admissible. I reserve the rest of my time to answer any questions that this tribunal may have. Thank you very much.
Thank you very much. Now I will give the floor to my colleagues in case they have any questions to the respondent on the procedural aspects on which they pleaded. Any questions? No questions from their side. I just have a couple of questions. Regarding the published statement from Mr. Vax, which would be basically me, does it matter on which capacity Mr. Vax published his statement, in your opinion?
There is a discussion, Mr. Chairman, regarding the social medias that the statement were made. But it is FIFA's understanding that since the comments did not bring any new information, since his position over vaccines were already established by his resume, it doesn't really matter in which social media he made the comments.
Okay, and it doesn't matter if he did it as president of an NGO or as an international arbitrator, according to your position, correct?
Yes, Mr. Arbitrator.
Okay, thank you. Then second question regarding the evidence itself, and in particular the hacked telegram. Did the FIFA Appeal Committee, are you aware the FIFA Appeal Committee analyzed whether the use of this telegram would violate human dignity as established in, or as would be forbidden by Article 46 of the FIFA Code of Ethics?
Mr. Arbitrator, it's not about engaging people in illegal activities to protect the sport or to violate human rights. But as we know, the Swiss law, the Article 152 of the Swiss Civil Procedural Code state that courts shall consider illegally obtained evidence if there is an overriding interest in finding the truth. As my colleague, Gustavo Awad, will further demonstrate, corruption has been one of football, the most important game in the world, biggest issues. and therefore justifies the existence of an overriding interest in finding the truth. So since the screenshot of the Telegram conversation can be used according to the Swiss law and the CAS procedural rules, it is FIFA's understanding that we are not violating any human rights.
Okay, thank you very much. No further questions from my side to the respondent at this stage. My colleagues still don't have any questions, I take it. Okay, so now we give the floor to the appellant for their pleadings on the procedural aspects of the case. Thank you.
Thank you, Mr. Presiding Arbitrator. Members of the panel, esteemed colleagues, my name is Firas Aidi, and as I already introduced myself, I will plead on behalf of the appellant in regard to the procedural issues. I'll do so in 10 minutes, saving 1 minute for rebuttal, and my co-counsel, Shahrazade Sabil, will do the same for the merits. We will mimic the same structure used by counsel for respondent to prove that first, CAS has a jurisdiction to hear the dispute. Second, the two challenges made over the lack of impartiality of Mr. Presiding Arbitrator, Mr. Vax, and Ms. Umaima should be upheld, and these two arbitrators shall be challenged and thus dismissed. And finally, with regard to the evidence, we submit to this panel that the two pieces of evidence, the screenshot and the anonymous witness statement, shall be inadmissible in these proceedings. To begin with our first submission, since counsel for respondent did not discuss it further, I will not elaborate on it. We also assert that this panel has a jurisdiction to hear the dispute. Moving on to our second submission, members of the panel, dealing with the challenges for Mr. Presiding Arbitrator, Mr. Vax, and Ms. Umaima. We'll be making two arguments. The first one dealing with the lack of impartiality of Mr. Vax, and the second one dealing with the lack of independence of Ms. Umaima. By virtue of Article R34 of the CAS procedural rules, if a party has legitimate doubts over the impartiality of an arbitrator, a challenge shall be formulated. We submit that based on the facts that we have at hand, we do indeed have a challenge to be made. We understand that this is not the correct venue in order to form such a challenge, as Article R34 gives us another procedure dealing with the ICAS. However, for the purpose of this hearing, we will be making the challenge before you, members of the panel. So I may simply give you the relevant facts. On one hand, we have the appellant, who is the face of an anti-vaccination campaign, has organized several events during universal lockdowns. On the other hand, we have Mr. Presiding Arbitrator, Mr. Andre Vax, who is the president of an NGO that deals with eradicating diseases. And to address the comment made by counsel for respondent, we are not basing our challenge over this quality of a president of an NGO. It is the wording in Exhibit 7 that gives rise to legitimate doubts over the impartiality of Mr. Vax. And regarding to the timing of said challenge, if I may refer you to page 4, paragraph 15 of the case law, we can of the fact pattern, we can clearly see that we had knowledge of this information. And I quote for the panel, 3 days before the hearing. That is why we are submitting it before this panel. And now if I may read you the wording used in Exhibit 7, and we will see how hostile it is to this community that is represented by the appellant. Mr. Andrevac said, as an independent arbitrator, referring to your question, Mr. Arbitrator, in his quality of an independent arbitrator on his LinkedIn account, he said, they have a free rider attitude. They are incredibly unfortunate and egotistic. They are uneducated people who think only about themselves. They are prone to conspiracy theories and constant exposure to fake news. Members of the panel, it is our submission that if these facts are given to any reasonable third person, it will immediately see that there is here a clear lack of impartiality of the presiding arbitrator. He already has a bias on this. And our legal background for this are the IBA guidelines, who are usable here and serve as a reference for this panel, since CAS did so already in the case UEFA versus FCCION. Finally, to give you another precedent outside of the CAS awards, which is a case deals with a judge who had clear opinion on the FN, which is a French far-right extremist party. In that case, and if I may give you the factual elements of it, the appellant challenged the chairman of court on the basis of Article 6, paragraph 1 of the ACHR. The appellant was part of the French National Party, which is an extremist political party in France. And the challenge was dismissed because there were not any personal or professionally taken position. However, here we do have a position taken professionally and personally by Mr. Vax. Thus, we submit that the challenges over the impartiality of Mr. Vax should be upheld and he shall be dismissed from this case. Moving on to the second element over the challenges dealing with Ms. Umayma, we submit that Ms. Umayma lacks independence in order to decide the dispute. And I urge you to look at all these elements as a whole, members of the panel. First, she has been appointed multiple times by FIFA, and this is clear in Exhibit 8 of the fact pattern. You will see that on the last page of the facts that we have. We do not dispute that this in itself is an issue of independence. However, if we look at this element, the fact that she did in fact disclose it only 5 days prior to the hearing, and when the appellant asked for further information, she did not yet provide this information. We do not know the verdict of the case, in which quality she had been appointed. All these elements give rise to legitimate doubts over her independence. Moreover, former in-house counsel of FIFA has recently joined her firm. And even if he was not involved in the proceedings, as we can see in the procedural order number 1, there are no guarantees that he will not be involved in this one. Members of the panel, we have a former in-house counsel of Respondent working alongside the arbitrator appointed by Respondent. Here, there is a clear conflict of interest, and this gives rise to legitimate doubts over her independence. Thus, to conclude on this issue, we submit that the challenge over the independence of Ms. Umayma should be upheld. She does lack independence, and she thus should be dismissed. Moving on to our last submission, members of the panel, dealing with the evidence, we will again follow the same structure used by counsel for Respondent, dealing with first the anonymous witness statement, Exhibit 4 of the case, and then with the screenshot, Exhibit 5 of the case. To begin with, I'd like to give two precedents that deal with the validity of anonymous witness statements. It will be the Pobeda case and the Quentin case. The first one is from 2009. It deals with match fixing, and the second one, the Quentin, is from 2011, and it deals with doping. In both these cases, an anonymous witness statement was presented, and for it to be admissible, 5 conditions were given. And I will give them to you in order to prove that none of them are fulfilled here. First, the witness has to provide a convincing motivation over the danger that he or she may have. There must be a possibility to see the witness for the panel and for the appellant. There must be a concrete risk of retaliation. The anonymous source must be questioned by the court, or at least have its identity confirmed. And finally, he or she must be cross-examined through an audiovisual protection system. Admitting an anonymous witness statement that does not comply with these conditions is a clear violation of the appellant's right to be heard. This is a clear violation of Article 6, Paragraph 1 of the European Court of the European Convention on Human Rights. Thus, members of the panel, we submit that this anonymous witness statement should not be admitted. The only case in which it has been accepted, and we can see that in the Pobeda case, is because the panel has an idea over the identity and was able to confirm the identity of the said whistleblower. Nothing of the sort is available in this case. Even you, members of the panel, do not have any idea over the identity of the said whistleblower. When we look at Exhibit 4, all we can see is a vaguely worded witness statement, which is almost completely redacted, and we cannot base a decision over this document. Moving on to the last submission we'll be making before this panel, we're dealing with the admissibility of the screenshot. We'll be making 2 arguments. First, that this screenshot is a forgery. Counsel for Respondent did not give any element to establish its authenticity. And in any case, if the panel deems it to be authentic, we submit that it has been illegally obtained and is thus inadmissible. Members of the panel, by virtue of Article 49 of the FIFA Code of Ethics, the burden of proof lies on the respondent. And when they provided the screenshot, they didn't give any further information. This is clear in the procedural order, members of the panel. And if I may refer you to it, you will see this in page 8, paragraph 22 to 24. To the questions, what is the date of the supposed Telegram conversation? The answer was, it is unclear. To the answer, was the anonymous source allegedly who hacked the appellant's phone available? They did not give any further information on this regard. We simply had an anonymous source that allegedly hacked the appellant's phone, gave Respondent the golden ticket that they needed that would prove exactly everything that they want, without giving us any further information. We do not have the date, we do not have the confirmation of the identity of the parties, we simply have a screenshot. Thus, we submit that it is a forgery, its authenticity has not been confirmed. And in any case, if you do deem it to be acceptable, we do submit that it has been illegally obtained in a clear violation of the appellant's right to privacy, and shall thus, by virtue of the duty to arbitrate in good faith and the integrity of the judicial process, be put aside in these proceedings. Thus, members of the panel, the 15 seconds that I have, I will conclude by stating that first, this panel has jurisdiction to hear the dispute that is undisputed by both parties. Two, both challenges should be upheld. Mr. Vax lacks impartiality, Ms. Umayma lacks independence, and they both should be dismissed from this case. And finally, the evidence that has been presented shall be inadmissible. The screenshot is a forgery, and the anonymous witness statement violates the appellant's right to a fair hearing. Thank you for your attention, and this concludes our submission. I remain available to answer your questions.
Thank you very much for your clear pleadings. Now, as we did before, I ask my colleagues, Ms. Rombach, Ms. Gomez, do you have any questions to the appellant on these procedural aspects?
Mr. President, I would have a question to the appellant regarding the challenge of Mr. Wex. We heard from the respondent that he cited the Sun Yan case decided by the Swiss Federal Tribunal and the facts of that case. Do you not see a distinction in this case from the Sun Yan case? And what I mean specifically in this case, did Mr. Wex not undermine his opinion with arguments that were different from what we can see in the Sun Yan case?
Well, thank you for your question, Madam Arbitrator. In the case that has been quoted by Counsel for Respondent dealing with the tweets in regard to the Chinese proceedings, we submit that this case resembles it. However, the consequences are different. If we submit the wording used by Mr. Vax to a reasonable third person, and we will let him know that the appellant is the face of this anti-vaccination campaign, then when we look at the word free rider attitude, unfortunate, egotistic, uneducated, thus here legitimate doubts will arise. We do not submit that this is beyond any reasonable doubts. The article R34 is clear. Only legitimate doubts give rise to a challenge. And we submit that this wording here gives enough elements for a legitimate doubt over his impartiality. Thus, if this answers the question, Madam Arbitrator, I'll conclude this point.
Yes, thank you very much. That answers the question. And I have another question regarding Ms. Uyama. Just so that I understand your argument, would you have challenged Ms. Uyama had she disclosed her multiple appointments right at the beginning of the proceedings?
I understand your concern, Madam Arbitrator. First of all, if the only element we have is the multiple appointments, we would not have made the challenge. This is clear in the IBA guidelines, footnote 5, under paragraph 313. It is accepted, especially in sports arbitration, with a closed list, that an arbitrator will be appointed multiple times. However, the fact that she disclosed that 5 days prior to the hearing, even though she had over 3 months to do so, the fact that she refused to give us any further information, even though she could have, and also the fact that a former in-house counsel of Respondent recently joined her firm, all these elements as a whole give rise to legitimate doubts over her independence, Madam Arbitrator.
Okay, thank you very much.
Thank you,
No
Madam
further
Arbitrator.
question.
Okay, I do have also a couple of questions for the appellant. With respect to the anonymous testimony, you have pleaded that this would be an inadmissible witness, if I understood you correctly. But do you, or for what reasons do you consider that this is actually a witness that FIFA has brought?
Well, Mr. Arbitrator, we do not consider this is a witness that FIFA has brought. In that case, would have applied Article 44 of the FIFA Code of Ethics that applies here. This is an anonymous witness statement that has been brought from another jurisdiction, which is the Harleidian judges. However, we cannot accept the argument made by Respondent, the fact that this whistleblower was heard by the Harleidian judges. The appellant was not party to that dispute. He did not have any confirmation of his identity. He was not able to cross-examine him. Thus, if FIFA bases their claim over this piece of evidence, they should again follow the rules that FIFA has issued, and the rules that this panel has already recognized in Pobeda and Quintador cases. And if these 5 conditions are not cumulatively met, the anonymous witness statement should not be admitted in these proceedings.
Okay, but you mentioned that you were not party to the criminal proceedings, that you were not able to cross-examine the anonymous witness. My question is, was FIFA party to the proceedings, and was FIFA able to cross-examine the witness?
In fact, FIFA was not party to this proceeding as well. It was before a national court with five officials that were indicted. However, the fact that FIFA relies on this piece of evidence clearly say that the burden of proof lies on FIFA. And if they will provide an exhibit to this panel in order for it to be analyzed, the appellant has the right, by virtue of Article 6, Paragraph 1 of the European Convention of Human Rights, to at least be able to cross-examine the witness, or even give us the slight indication that this is indeed a reliable source that does not, for example, has a personal vendetta against the appellant and is thus pursuing a personal goal. And to further address your question, Mr. Arbitrator, if I may, if this witness statement was provided before the Hardadian judge and the appellant could thus be identified, why wasn't he involved in these proceedings? 5 officials were indicted and convicted, but the appellant was not one of them. So if this anonymous witness statement was also presented before the Hardadian judges and they did not feel compelled to include the appellant in the proceedings, we submit that this panel should not also do the same. If this satisfies the question, I'll conclude on this point.
It does. Thank you. Thank you very much. Then on another question concerning the burden of proof, you have mentioned in your pleadings that the burden of proof lies in FIFA. My question is, I mean, I think that is common ground. I think everyone agrees that that's what Article 49 of the FIFA Code of Ethics establishes. My question would be, do you consider that the appellant also shares or has some sort of obligation to establish facts and to prove the facts that it alleges? Or is it only FIFA?
Well, FIFA is in the first proceeding before the ethics committee, the claimant, thus it had the burden of proof. However, to strictly address your question, also the appellant in these proceedings can have a possibility to prove piece of evidence. However, if we take the words of counsel for respondent for granted, that would mean that the appellant will have the burden to prove that something that we have here does not exist, and that is a diabolical proof, as we have established in all legal systems. Thus, the burden of proof, when it is simply disproportionate, it cannot lie on the party that simply is in the impossibility to prove a diabolical piece of evidence. Thus, to address your question, the burden of proof lies on FIFA, but on the elements on which it does lie on the appellant, it simply does not, because FIFA does not establish relevant facts for the appellant to prove the opposite.
Okay, thank you very much.
Thank
Any
you.
of my colleagues have any follow-up questions? No? Okay, perfect. So now we will give the floor to the respondent for the 1-minute rebuttal, if I'm right.
Thank you, Mr. Chairman. Members of this tribunal, the challenge against Madam Umaima is groundless. My opposing counsel urged this tribunal to look at the element as a whole. But if you multiply something for 0, the result is still 0. The in-house counsel of FIFA was hired 14 days ago, and the email informing this was sent 13 days ago. He does not work directly with Madam Umaima. He never dealt with Mr. Adams' case, not as a member of FIFA legal team, not as associate of Madam Umaima partner. In addition, the IBA guideline indicates that no disclosure of the repeated nomination is required, and therefore it cannot raise doubt as to her impartiality. No matter how much appellant argues, there are no grounds to dismiss Madam Umaima from these proceedings. Thank you very much.
Thank you very much. Unless my colleagues have any questions, which I take it is a no, then we give the floor to the appellant for the minute rebuttal.
Thank you, Mr. Presiding Arbitrator. We'll address the 3 points raised by counsel for respondent. First of all, the fact that a former in-house counsel of Respondent is working with Madam Umaima, as I have already stated, is enough to prove a lack of independence. Moreover, counsel for Respondent could not give you any guarantees that even if the former in-house counsel has recently joined her firm, he will not be working alongside her, giving her inside information over the functioning of FIFA, over elements that could help FIFA's case. In regard to the second element that was submitted by counsel for Respondent, we do not dispute and refer to the question again, Madam Arbitrator, the multiple appointments. We are disputing the fact that it has been disclosed late and the scope of disclosure was not complete. When we asked for relevant information, Ms. Umaima refused. Thus, we submit that the challenge over Ms. Umaima's lack of independence shall be maintained and she shall be dismissed. Thank you, members of the panel, for your attention. This concludes our rebuttal.
Okay, thank you very much. So again, no question from my colleagues, members of the panel. No, perfect. So then this will take us to the section of the merits. So therefore, I think the floor now would be with the appellant.
Thank you, Mr. Presiding Arbitrator. Members of the panel, esteemed colleagues, as previously introduced by my co-counsel, my name is Shahrazade Sabil, and I'll be representing the appellant, Mr. Aitam, in this case against FIFA, regarding the merits. To begin with, I would like to emphasize how outrageous FIFA's relentlessness and accusations against Mr. Aitam are. He's an honest and qualified man who has been wrongfully sanctioned by FIFA, who never stops abusing its power to assert its authority. On the merits, it is the appellant's submission that first, he did not breach Article 27 of the FIFA Code of Ethics, and two, that the sanction imposed by virtue of the FIFA Appeal Committee is disproportionate. Starting with the first submission. As a preliminary remark, I would like to remind the panel that the burden of proof lies on FIFA according to Article 49 of the FIFA Code of Ethics. Thus, it is for FIFA to prove that Mr. Aitam breached Article 27 and that the standard of comfortable satisfaction is reached. And the standard is mentioned in Article 48 of the FIFA Code of Ethics. And regarding that standard, Professor Antonio Rigazzi, in his abstract Eventuary Issues Before CAS, mentioned two cases, Andrew Cornett cases and Guliev cases from 1996. And in this case, CAS has stated that the more serious the allegation being considered, the greater is the degree of evidence. Here, we submit that respondent failed to give sufficient evidence to prove that Mr. Aitam did actually breach Article 27. This article puts out 4 conditions that must be cumulatively fulfilled in order for an offense of bribery to occur. First, the person acting must be bound by the FIFA Code of Ethics, and we are not arguing this condition since Mr. Aitam is the president of a football federation, therefore bound by this code. Moving on to the second and third condition that must be understood as a whole, the person involved must have accepted, given, offered, promised, received, requested, or solicited a personal or undue pecuniary advantage or any other advantage. And here we submit that, again, respondent failed to give sufficient evidence to prove that Mr. Aitam accepted these kind of advantages. Indeed, the only thing Mr. Aitam accepted was to go to Bigland for purely professional matters. He responded to Mr. Kayser's invitation that you can find in Exhibit 1. And if the panel is following me, I will simply quote the meaning of this invitation was to, and I quote, visit the capital and discuss further business opportunities between the two federations. And because of the upcoming elections, Mr. Aitam went there to visit the touristic points, the stadiums, and the sports facilities, as it was clarified in PO 1, page 5, paragraph 3. The appellant actually wanted to see if Bigland was a better fit for hosting the 2026 World Cup. And it is a custom in the football community that one official go visit another. It's great publicity for the federation, and it's a great way to expand your address book. Additionally, the appellant would like to reaffirm that he did not accept any watches contrary to what the opposing counsel might say after this pleading. Mr. Kaiser also did not pay for any luxurious parties and festive restaurants, as it has been wrongfully stated in Exhibit 4 that should be held inadmissible, as my co-counsel stated earlier. And again, the respondent failed to provide any invoices, and it cannot hide behind its restrictive powers of investigation. Respondent was able to get the exact price of the plane ticket. It was able to get the exact price of the hotel nights, but not for the watches or the restaurant bills. And this is simply because Mr. Atom never received or accepted these advantages. Furthermore, the appellant would like to insist on the fact that he did nothing but act in good faith. He was invited by Mr. Kaiser, so it's normal that the host is paying for the plane tickets and the hotel rooms. Furthermore, the panel should keep in mind the context. It's a World Cup election campaign, and the fact that Mr. Kaiser is the president of a huge profitable federation, FFB. Thus, 19,500 Swiss francs is not of a nature to arouse suspicions. Finally, Mr. Atom reimbursed Mr. Kaiser for everything he paid. And if you add up all the expenses for the hotel and the plane tickets, the total sum amounts to 19,500 Swiss francs. And therefore, by reimbursing everything Mr. Kaiser paid for, Mr. Atom showed his good faith. Therefore, the appellant did not go or accept or receive undue pecuniary advantage or any personal advantage. And on that point, we already anticipate respondents' arguments regarding the timing of the reimbursement. You can find the reimbursement in Exhibit 3. Mr. Atom reimbursed 20,000 Swiss francs to Mr. Kaiser. However, why would the appellant reimburse anything before finding out that Mr. Kaiser was a man who tried to corrupt many officials? He was acting in good faith during the trip and the months following. Not for a moment did he have any doubt that Mr. Kaiser was unethical or that he tried to manipulate him in vain. Finally, the last condition that must be met is that these advantages must be given in order to obtain or retain business or any improper advantage. And here, we submit that Mr. Atom did not know that he was being offered the trip to do something. The appellant freely voted for Bigland, as he consistently stated since the beginning of the FIFA's proceedings. The appellant thought that Bigland was a better fit for hosting the World Cup. This country objectively presented all the required qualities in order to host such an event. And this was actually the opinion of the other 100 delegations who voted for Bigland during this election. Therefore, the panel should consider that not all elements of Article 27 are reached and that the appellant did not commit any acts of bribery. Moving on to the appellant's last submission on the sanction. As a reminder, the appellant was sanctioned of a 15-year ban and a 50,000 Swiss francs. Since the appellant argues that he did not commit any act of bribery, the sanction should be simply annulled. However, if the panel were to find that the appellant's act did violate the FIFA Code of Ethics, it should consider that the sanction imposed by the FIFA Appeal Committee are disproportionate, since they're evidently and grossly disproportionate. According to the Metalis case rendered by CAS in 2013, a sanction must comply with the principle of proportionality in the sense that there must be a reasonable balance between the kind of misconduct and the sanction. And since cases before CAS are heard de novo, as it was explained in the Kwesi-Nyantaki case from 2020, the panel should take into account the specific circumstances of each case to determine if the sanction is proportionate or not. And here, in this case, there are circumstances that should be taken into account and that were taken into account by CAS in numerous cases. For example, the fact that much shorter sanctions were awarded in cases with very broadly similar facts, or a fortiori, more serious facts, more serious facts. For example, I can quote the Michel Platini case from 2016 that shows that CAS has already reduced sanctions in cases with much larger sums and serious facts. In this case, it was a case of corruption involving 2 million Swiss francs, and Michel Platini was only sanctioned for a 6-year ban and a 60,000 Swiss francs fine. Other elements that can be taken into account or the fact that it is the perpetrator's first offense, that there is a low value of the gift allegedly accepted by the person, and that this person has returning this advantage, for example, by reimbursing the person that gave these advantages. It is the case here. We are, in fact, in this particular case, facing a preemptive and unfair justice by which FIFA is trying to condemn the appellant for an act he did not commit just to set an example. And this practice is totally unacceptable. And it is not your role, members of the panel, to set an example out of someone. Your role is to ensure that FIFA has not abused its powers by sanctioning so severely the appellant. A simple warning or reprimand, according to Article 7, Paragraph 1 of the FIFA Code of Ethics, would suffice in this case. In light of all these submissions, the appellant respectfully requests the panel to declare that Mr. Etam did not breach Article 27 of the FIFA Code of Ethics, and therefore that the sanction should be annulled, and alternatively, to reduce the sanction imposed by virtue of the FIFA appeal decision, since it is disproportionate. Mr. President Arbitrator, members of the panel, these conclude my submission, and I thank you for your time and attention.
Thank you very much. I now give the floor to my colleagues in case they have any questions to the appellant.
Hello. Yes, I have a question.
No problem.
Thank you very much for the submissions. I was wondering, isn't the reimbursement acknowledging the nature of the amount spent was illegal?
I'm sorry, Madam Arbitrator. Can you repeat, please? I didn't quite hear you. Sorry.
Yes, of course, no problem. Isn't the reimbursement that the appellant made a way of acknowledging the nature that the nature of these amounts spent was illegal?
I understand your concern, Madam Arbitrator. However, this reimbursement cannot be seen as an admission of guilt or a way that can be seen as the Mr. Etam realized what he has accepted or received. This is simply a reimbursement. Mr. Kaiser paid for things, for the accommodations and for the plane tickets. And surely when Mr. Etam realized that maybe this was not a simple professional matter, he just reimbursed this sum as a sign of good faith. And the panel should keep in mind that the appellant only acted in good faith at the time when he reimbursed. He just realized that this might be a case of bribery, or that Mr. Kaiser tried to incite him. However, at that time during the trip, he did not for a moment did he thought that he was being bribed. And this satisfies you, Madam Arbitrator. This concludes my points.
Thank you.
Thank you, Ms. Rombach. Do you have any question? No question. Okay, I do have a couple of questions also for the appellant. You have stated that this is a standard practice in the football community. Are you aware of Mr. Etam having attended many similar trips as the one to Bigland?
Unfortunately, I will have to ask my client about that. However, we do know that 18 delegations of national football federations traveled to Bigland through 2016, as it was stated in the procedural order number 1, page 7, paragraph 15. And this clearly shows that it is standard practice, especially before an election, that federations and especially their presidents go visit each other. But I have to ask this question to my client. However, for example, in the Brazil World Cup in 2016, many federations visit Brazil to have a look on how the organization would be if the Brazil would host this World Cup.
Okay, thank you. Then you have mentioned the Platini award when you were referring to the you were comparing, let's say, this case with the one of Mr. Platini. In that case, or how do you factor in that case, Mr. Platini was sanctioned for offering and accepting gifts and not for a case of bribery, as in this case? Does it have any impact in the way the panel should look at that other case and when comparing it to this one?
Thank you for your question, Mr. Arbitrator. Well, we do believe that this case clearly shows that FIFA, in some cases, abuses its power by sanctioning persons who accepted advantages or undue advantages. And here, obviously, in this case, in the Platini case, CAS thought that the sanction imposed by FIFA was disproportionate. This is the reason why they reduced it. And we urge this panel to apply the same analysis of this case. FIFA did sanction Mr. Atom with a grossly disproportionate sanction. Therefore, just like the Michel Platini case, or for example, just like the Fouzi Maloy case, you should reduce the sanction, especially, and I will again refer to the Platini case, 2 million Swiss francs were involved. It was a huge case of corruption. However, CAS has reduced the sanction. Therefore, we urge this tribunal to reduce the sanction in this case too.
Okay, thank you very much. Then you also mentioned that as one of the elements that would warrant the reduction of the sanction, the fact that this would be the first offense of Mr. Atom. My question is, the fact that this is a first offense, is this a mitigating circumstance, or is it just a lack of an aggravating element?
Well, we argue that this element should be used by this panel to understand the facts of this case. Mr. Atom is qualified. Mr. Atom is honest. Never in his whole presidency in the FFT has been involved in any problems, any proceedings before FIFA. And we do believe that this element shows that clearly, if you consider that Mr. Atom should be sanctioned, a 15 years ban and a 50,000 Swiss francs would be too much disproportionate for him, since he proved himself that he proved to the FIFA and to the football community that he was an honest man and that he was acting in good faith.
Okay, thank you very much. No further questions from my side. I take it that my colleagues don't have any other questions, so then we can give the floor to the respondent.
Good afternoon, esteemed panel, esteemed colleagues. In affirming the appeal decision, FIFA will now look at the merits issues. As a threshold matter, FIFA will argue inter alia that, firstly, the standard of proof is not simply that of comfortable satisfaction, as argued by Ms. Sabil. As shown through numerous precedents, including the cases brought jointly by the appellant and FIFA themselves, the applicable standard of proof is flexible and shall consider the concealed nature of corruption cases and the personal conviction of the CAS panel. Secondly, the requirements under Article 27 of the FCE are fully met, and as stated in paragraph 44 of the appeal decision, fully absorb Article 21 and Article 25 of the FCE. Thirdly, as will be proven by FIFA, the sanction imposed in the appeal decision is proportional. In fact, it is manifestly lower than most of the recent decisions under Article 27 of the FCE, previously Article 21 of the FCE, should Lex Mator apply. The cases brought by the appellant all date back to more than 5 years ago, except for one. Case law regarding corruption and bribery has adapted so much over the past 5 years. This is a growing concern in FIFA. FIFA hereby emphasizes its zero tolerance approach to corruption that has long plagued our beautiful game. We would like the panel to understand that this case is of utmost importance, and we kindly ask the panel to appreciate the malice that corruption and bribery have brought to the football family as a whole. the basis of a World Cup bid shall only consider the bid's intrinsic worth. Next, the appellant's point regarding the applicable standard of proof shall be dealt with. The standard of proof is defined as the level of conviction that is necessary for a panel to conclude in the arbitral award that a certain fact happened. Article 51 of the FIFA Code of Ethics 2012 edition determined that the standard of proof shall be one of personal conviction, whilst Article 48 of the FIFA Code of Ethics from 2018 onwards establishes this term as comfortable satisfaction. In practical terms, this standard of proof of personal conviction is aided with that of standard of comfortable satisfaction. It's a leading and established principle throughout multiple caste jurisprudences involving the FCE that, quote, the sanctioning authority must establish disciplinary violation to the comfortable satisfaction of the judging body, bearing in mind the seriousness of the allegation. It is a standard that is higher than the civil standard of balanced probability, but lower than the criminal standard of proof beyond a reasonable doubt. This is seen in CAS 2016 A4501, Exhibit 13, paragraph 121 of the respondent submission, and also submitted as Exhibit 9 of the appellant submission. This view is particularly relevant in corruption and bribery cases in light of the fact that the investigative powers of FIFA are extremely limited. In this regard, it is clear that the panel shall appreciate the peculiarity of the evidence related to corruption and its standard of proof, as consequently, direct evidence in relation to corrupt activities will be rather the exception and indirect evidence the standard. Next, and with these preliminary points in mind, FIFA's analysis now looks at the violation of Article 27 of the FCE, for which there are no doubts that there were multiple applicable incidents. First, Mr. Adam is bound by the FCE, for he's an official of FFT in Thailand. He accepted, he promised, and he received a personal or undue pecuniary or other advantage in order to obtain or retain business or any other improper advantage to or from anyone within or outside FIFA. It is clear that Mr. Adam, together with Mr. Landers, accepted a personal advantage whilst being treated to a luxurious, all-inclusive stay in fancy capital in Big Land. In fact, it is not contested by the appellant in any way. Mr. Aidi simply stated that the details of the testimony were redacted in some points, and Ms. Sabil simply stated that there is no receipt for a luxurious watch or dinner. This receipt is with Mr. Kaiser, who bought them these gifts. The trip took place during the course of a full week. Mr. Adam stayed in a luxurious hotel. Mr. Adam received a luxurious watch. Mr. Adam was treated to a dinner at a Michelin-starred restaurant. He attended a lavish party, was treated to free massages and spas. In fact, Mr. Adam didn't pay for anything during his trip. Ms. Sabil also states, albeit quickly, that a friendly match is not considered an undue or personal advantage. FIFA firmly disagrees. And as the panel is aware, there's much more to the story. When it comes to gifts or other advantages accepted, case law holds a wide-ranging scope of application. As explained in Exhibit 9, paragraph 113, CAS 2019 A6220, quote, the advantage can take any form and need not to actually materialize, and is it sufficient that someone offers or promises it, end quote. I want to bring attention that these gifts took place over a week where, in fact, Mr. Adam has had more than enough time to realize his positive obligation to refuse an improper offer instead of simply omitting to act upon it. It is well established that, quote, an official cannot escape liability by remaining inactive or silent in an attempt to corrupt him, end quote. This is seen in Exhibit 9, paragraph 136, CAS 2019 A6220. Here, Mr. Adam not only fully remained silent, but fully experienced all the perks being offered. As to the third criterion, we revert to paragraph 53 of the appeal decision. The acceptance of the appellant in relation to a potential friendly free of charge, as well as an upfront waiver of any compensation for such a match, indeed represents an undue advantage for the appellant's wife, who is a shareholder of the only football broadcaster in Thailand. It is immaterial, as just mentioned, that such friendly did not take place. Finally, as to the last criterion, it is clear that Mr. Kaiser's motive was to retain a vote for Big Land to host the 2026 World Cup in detriment of losing land. FIFA is thus comfortably satisfied that the appellant well understood that he was being incited by Mr. Kaiser to behave dishonestly. For example, to vote on the basis of the advantages offered rather than on the basis of the bid's intrinsic worth, exactly like in paragraph 127 of Exhibit 16, CAS 2011 A2426, which is also brought by the appellant as Exhibit 5. There is a clear quid pro quo relationship between Mr. Kaiser and Mr. Adam. Next, in regard to proportionality, FIFA notes that Mr. Adams' actions in the whole were particularly egregious. As to the other precedents named by the appellant involved more than one charge, FIFA brings attention to the panel that it must examine the seriousness and nature of the offenses identified in those cases in comparison with the most serious offense committed by Mr. Adam. FIFA also brings attention to the panel, as affirmed in the Blatter decision, again brought by both parties to the current proceeding, that, quote, CAS panels have limited discretion to review sanctions imposed by disciplinary bodies of federations when such panels make similar findings, and such discretion should only be exercised when the sanction is evidently and grossly disproportionate to the offense. This is seen in the preamble of the Blatter decision, Exhibit 13 of the respondents, and Exhibit 9 of the appellants. Thus, when analyzing most sections under Article 21 of the FC 2012 edition, now Article 27 of the FCE in the past years, and as seen in paragraph 498 of the Downero decision, CAS 2019 A6344, Exhibit 1 of the respondent submission, we clearly see a ban for a lifetime ban from the sport. A simple warning or a reprimand would not suffice, as stated by Ms. Sabil. Ms. Sabil also mentioned that the Platini case and the value being contested of 2 million Swiss francs. This is exactly the problem that FIFA is submitting to the CAS panel. It is irrelevant if it is more or less than any other precedent. Corruption is corruption, and this is exactly the problem that has been plaguing our beautiful sport. In fact, as seen in 498 of the Donato decision, paragraph 498 of the Donato decision, we see Article 27 and Article 21 over the past 4 years. We see that Mr. Webb, Mr. Esquivel, Mr. Tacas, Mr. Davidson, Mr. Trujillo, Mr. José Maria Marin, Chiriboga, Mr. Osuna, Mr. Loez, Mr. Figueiredo, Mr. De Luca, Mr. Mesnier, all in the past 4 years have received the ban for life and a fine of 1 million Swiss francs under Article 27 or 21 of the previous FCE decision. Now, in regards to mitigation, and to conclude my pleading, the argument made by Ms. Sabil that the reimbursement was done in good faith is thus moot. It is uncontested by the appellant, as clearly seen in Exhibit 3 of the SAM case, that this is in fact a reimbursement. If anything, when the reimbursement is done the next day following the conviction in Hardland, this further aids to the guilt of Mr. Adam. In fact, we have a plethora of aggravating circumstances. Mr. Adam was one of the highest ranking football officials in the world during the events in questions. Mr. Adam was as the president of the Football Federation in Thailand. Mr. Adam was one of the many individuals involved in a wide-scale, far-reaching, sophisticated corruption scheme. Mr. Adam has shown no remorse for his actions, and indeed throughout the entire duration of the legal proceedings here before FIFA and the CAS has maintained that all the considerable evidence against him was false, incomplete, misleading, unreliable, or inadmissible. In this regard, and on the spirit of preserving the integrity of the football family and banishing the malice that is corruption, the appeal decision must be confirmed in its entirety. Thank you very much.
Thank you very much. As usual, I will give the floor to my colleagues for any questions that they might have.
Yes, if I may, I would have 2 questions, Counsel. My first question is, could you clarify your position or your arguments in terms of the contested evidence? We do have the problem as a panel that potentially some of the evidence might not be admissible, which we will have to decide on. Just assuming for now that the telegram messages and the witness statement, the statement of the anonymous witness would not be admissible, would your case still stand as it is?
As I stated in my speech, the investigative powers of FIFA are extremely limited, and in all comparable cases of corruption, it has been stated that the concealed nature of corruption and bribery cases, exactly because it's such a concealed matter, evidence in this light has to be treated in a more flexible manner. If this evidence were not to be admitted, we have a plethora of other evidence that clearly states that there was a trip, that the circumstances around the vote, or we know that the vote was done to Big Land. So there's a whole what the panel has to appreciate is all the elements, not only two exhibits that may or may not be admissible, although we see absolutely no reason for it to not be admissible. This is clearly a case of contextualizing everything. Corruption is a matter of contextualization due to its concealed nature.
Okay, so even without the evidence that is at contest here, you would still plead that the prerequisites of Article 27 were met?
Could you confirm exactly what pieces of evidence? I'm understanding that it's Exhibit 4 and Exhibit 5, right? The SAM case.
I have to
Exhibit 4 would
apologize.
be...
I don't know. I'm not aware of the exhibit number, but I'm talking about the telegram messages on the one hand, and the witness statement of the anonymous witness on the other hand. These are the two pieces of evidence that are at issue here in terms of admissibility. And just assuming we would strike them, I understand your position would be that the other evidence is still sufficient to meet all of the requirements.
Well, FIFA's position is that like I said, Exhibit 4 and Exhibit 5 of the SAM case is that this is a matter of contextualization. These evidences are extremely important to the case and should be treated as such. So when the panel appreciates this, we would like the panel to appreciate FIFA's position. We are tired of having to come to CAS to defend people who are being accused of corruption and bribery. This is happening every year, and it's simply not productive.
Okay, thank you very much. And I have a second question, and that question relates to proportionality. As you are aware, when we make a final award, that award has to withstand before the Swiss Federal Tribunal if either party challenges that award. What troubles me and us as a panel at the moment is the 15-year ban imposed on a 55-year-old individual. Is it not that this would essentially deprive the appellant from fulfilling or exercising his profession for the rest of his life? He would be 70 years old when the sanction expires. Could we come into trouble in terms of the public policy restriction that the Swiss Federal Tribunal would review? I'm not sure if you are aware, for example, of the Matusalem case where this was an issue, or put it really briefly, is 15 years not too long in terms of that it deprives the appellant of essentially his further employment for the rest of his life?
Thank you for your question, Ms. Rombach. The idea of sanctioning an official is to prevent recidivism and to prevent others from doing the same. In that sense, and as I stated in my speech, a lot of the recent decisions of Article 27 involving José Maria Marinci, Mr. Chiriboga, Mr. Osuna, Mr. Loez, Mr. Figueiredo, Mr. Luca, Mr. Meusnier, indeed led to a ban for life. It is immaterial in FIFA's mind that someone receives a free wild card to commit corruption and bribery cases depending on their age. It is obvious in a certain degree that those who are higher positioned in a federation have had a career that led them to these positions. So in most cases, the officials being charged are of a certain older age, but this should in no way be seen as a mitigating circumstance. This is exactly what we're trying to banish. If we start being lenient to those who are over 55, then we're giving others a free card to do whatever they want the older they are.
Thank you very much. No further questions.
Perfect. Ms. Gomez, do you have any questions? No? Okay, I do have a couple of questions also for the respondent. First, with respect to the element of the ratio of equivalence or the quid pro quo element that must appear in any case of bribery, do you see any issue with the fact that I think it's 8 months or almost 8 months elapsed between the trip and the moment where Mr. Atom had to vote for the election of the host of the World Cup?
Thank you for your question, Mr. President. I do not see any issue. This was a sophisticated bribery and corruption scheme perpetrated by Mr. Kaiser, and as we saw with the conviction in Hardland, involved multiple football officials from various countries. It is irrelevant that it happened, in our opinion, that it happened 8 months before. If anything, it shows that Mr. Adam had even more time to reconsider and to reimburse the expenses, only waiting to pay the subsequent day after the criminal conviction in Hardland. Mr. Adam has to understand that there is more than enough evidence against him in this situation.
Okay, and also with respect to the actual amounts that Mr. Atom received, because here we're talking about assigning the World Cup, which, as you might, well, as your FIFA, you will know the vast amounts of money that this entails. So if we were to accept, and I understand that you accept that Mr. Atom reimbursed the full amount of what he received, which is 20,000 francs, would this be enough, like the amount that he received or the bribe that he received, would this be sufficient in view of the amounts that then the big land would obtain as a result of Mr. Atom's favorable vote?
Thank you again for your question, Mr. President. I'd like to answer this question by posing a question towards the appellants, in the sense that where did they find this complete value? We see in page 3 of item 9 of the case, it says, quote, although Mr. Adam was not involved in the Hardland criminal proceedings on 8 September 2018, he decided to transfer 20,000 Swiss francs to Mr. Kaiser's reimbursement for his and Mr. Lander's trips to Big Land. So are we just to take Mr. Adams' word as the complete truth? There's much more than the trip, than the stay at the hotel. Here we saw that there was a lavish party, that there was a luxurious watch. There are so spas. There were so many presents that FIFA is not satisfied that 20,000 is the full amount. The full amount is unquantifiable at the moment, in the sense that it's not simply 20,000 in our minds.
Okay, thank you very much for that. Then the last question would be, did FIFA try at any moment in time to contact the anonymous whistleblower?
Well, the anonymous whistleblower was a witness, was not a FIFA witness. It's a witness from the Hardland criminal proceeding. It's thus not FIFA's position to try to identify this anonymous whistleblower. However, in preserving and trusting the legal system in Hardland, we believe that this would go beyond the scope of FIFA and its investigative powers.
Okay, so if we were to consider that the anonymous whistleblower is to be considered a witness, would you see any issue with the fact that FIFA didn't even attempt to call him as a witness, so that the appellant could cross-examine him during the hearing, and that the panel could have access to this person?
We did not, like my colleague Thomaz said, anonymous witness statements are admissible, especially when preserving the truth is at stake. And as I mentioned before, it is not FIFA's position to try to contact this anonymous witness. We're trying to preserve the integrity of Hardland as a country, and believing in the judicial system, believing that this anonymous witness was liable to perjury, believing that they are in fact being preserved for a reason. That's my answer to the question.
Okay, thank you very much, counsel. So now,
may I ask
yeah,
a small question? I was wondering, why do you deem that the appellant was not heavily sanctioned in the Heartland procedures?
Could you please repeat the question?
Yes. Why do you deem that the appellant was not heavily sanctioned in the Heartland procedures?
The appellant was not sanctioned at all in the Heartland proceedings. The appellant was not party to it. I don't believe I stated that.
And why do you think it was not a party to those procedures?
I don't know in terms of personal jurisdiction and subject matter jurisdiction, but it must be a matter that the 5 convicted in Heartland were most likely applicable to the jurisdiction, maybe nationals or those who live there. Yeah.
Thank you.
Perfect. Thank you very much for your question. So now this will take us to the appellant's turn for the rebuttal.
Mr. Presiding Arbitrator, may I ask for an additional 30 seconds just to first address the opposite counsel's question and then go on to my rebuttal?
Of course, then the only thing is the respondent will have the same time.
No problem. Thank you very much, Mr. Presiding Arbitrator. First of all, to address the opposite counsel's question, Mr. Atom did not come up with this number out of a hat. If you go to procedural order number 1, page 5, paragraph 4, and you do a quick addition of all the amounts paid by Mr. Kaiser, you'll find that Mr. Kaiser paid for 19,500 Swiss francs for the whole trip. And this concludes my answer to the opposite counsel. On the rebuttal, I would like to address first that if we take out the screenshots and the anonymous witness statement, respondent has nothing, and I insist on that, nothing on the fact that Mr. Atom allegedly breached Article 27. Moreover, the standard of comfortable satisfaction cannot be reached here. The only evidence we have that allegedly proves that Mr. Atom breached Article 27 are a forgery and an inadequate statement made by an anonymous person. And if I may direct you to Exhibit 4, this person could not identify these individuals, paragraph 13, as they were facing their backs. Paragraph 14, he heard most of what was being said. Paragraph 18, that I turned my attention to my emails for a while. Paragraph 20, it became increasingly difficult to follow the conversation. What I want you to understand, members of the panel, is that we do not have here a satisfying evidence that could enable you to reach to a comfortable satisfaction in order to find Mr. Atom guilty. This concludes my rebuttal, and I thank you for your attention.
Thank you very much. So now the floor is for the respondent, and as the appellant, you have also 30 seconds more than the initially allotted time.
Thank you, Mr. President. In regards to the witness statements and its redacted versions, of course, a conversation that's happening in a restaurant that is next to you is not, the person is not going to recollect the full conversation, but it is obvious that the whistleblower recollects the main points of the conversations because they were shocking. It's a matter that the whistleblower took to so much at heart that she or he remembered exactly the circumstances. Corruption in itself is frustrating, and it makes everyone remember when a bribery scheme is being proposed next to them, the circumstances around that.
Thank you very much. Okay, so unless my colleagues have any further questions, which I take it is a no, then this would bring us to the end of today's hearing. Before we move on to the deliberations and before we bring an end to this hearing, I would like to ask the parties whether you consider that your right to be heard has been duly respected. The appellant, please.
Yes, on behalf of the appellant, we do indeed agree that our right to be heard was fully respected. Thank you, Mr. President, members of the panel.
Thank you.
On behalf of the
Respondent.
respondents, we also agree. Thank you, Ms. Gomez. Thank you, Mr. Rombach, and thank you, Mr. Cambreleng.
Thank you very much. Thank you for your very clear pleadings. You've made our job very difficult, and we will